Good afternoon, everyone, and welcome to our discussion about state privacy laws in the United States, new developments, and there are a lot of new developments. I have with me here Libbie Canter from Covington. Libbie has focused many years on the state law developments, has spoken about this topic in workshops at my event for many years and really has been following this incredibly closely. So I'm really delighted to have her here today to talk about some of these developments. So, Libbie, my first question for you is can you describe where the current landscape is with the state privacy laws? I believe that we counted now 13 laws, perhaps 14 if we count Nevada, which is a very bare bones, very minimalist law. But that's quite a lot, and a lot that were passed this year. So I'm curious your take of this landscape. How are these laws similar? How are they different? Are there any notable outliers in this? Common approaches? What's your take on what things look like here?
Yeah, so I do think California has become somewhat of an outlier. It came first, and was enacted and went into effect in 2020, and then has since been amended. The amendments that were part of the California Privacy Rights Act ballot initiative came into effect in 2023. And it's different in that it has a different vocabulary. It talks about businesses and service providers rather than controllers and processors. Instead of a right to opt out of processing for targeted advertising, it talks about sharing, which is defined as sharing for cross-context behavioral advertising. It applies in the employment and commercial context, which most other states don't. It has really prescriptive and idiosyncratic requirements for privacy notices and landing pages, and it has a narrow private right of action for certain data breaches. Whereas the other dozen laws that you mentioned, I think kind of can fit within a spectrum. And Virginia kind of came first for the second set of laws. So I would put Virginia in the middle. And I think you have states that are Virginia minus. So they don't have all the bells and whistles of Virginia. And then you have some states like Colorado and Connecticut that are Virginia plus, where they have more. So just to expand on that, all of these have some core elements like access, deletion, and portability rights. The Virginia model and the Virginia plus model have correction rights. The Virginia minus model doesn't have correction rights. The Virginia model has 3 different opt-out rights to opt out of the sale of data, processing for targeted advertising, and profiling in furtherance of decisions that have legal or similarly significant impacts. The Virginia model requires consent to process sensitive data, and the Virginia model has other controller obligations like reasonable security measures, data protection assessments, certain required contract language for processor agreements. But then on the Virginia minus side, in addition to not having a correction right, there's no right to opt out of profiling. Instead of having an obligation to obtain consent to process sensitive data, it's a right to opt out of processing of sensitive data. There's no obligation to conduct data protection impact assessments. There's some lighter touch contractual requirements and processor agreements. And while within the Virginia model, you have some states like Virginia that define, and Indiana that define sale narrowly as an exchange of personal data just for monetary consideration, whereas other states define it more broadly. All the states in the Virginia minus category define sale narrowly just as an exchange of personal data for monetary consideration. So I'd put the Virginia minus states as Iowa and Utah. I'd put the Virginia states as Virginia, Tennessee, Indiana, and then Florida, although we'll talk about some idiosyncrasies, I'm sure, shortly. And then in the Virginia plus category, these are states that have all the stuff in Virginia, the correction rights, data protection impact assessments, et cetera, but they also have obligations to recognize universal opt-out mechanisms as a modality to exercise opt-out rights. And they have typically additional protections for 13 to 16-year-olds. So the Virginia model treats data about children under 13 as sensitive data for which consent is required to process. And in that context, parental consent, and they often cross-reference COPPA. The Virginia Plus model has some additional protections for 13 to 16-year-olds. So typically, whereas the default framework provides consumers the rights to opt out of the sale of their data or processing for targeted advertising, the states that have these additional protections provide an obligation to obtain opt-in consent if you're selling or processing data about these minors for targeted advertising purposes. And then these states all define sale more broadly as an exchange of data for monetary or other valuable consideration. And in some cases, they have additional obligations in processor contracts, for example, rights that controllers have to reserve to reject subcontractors and things like that. So in this bucket, I would put Colorado, Connecticut, Montana, and most recently Oregon and Delaware. I haven't mentioned Texas yet because I think it kind of goes in between the Virginia and the Virginia Plus categories. It doesn't have special requirements for minors over 13. It does require businesses, though, to honor opt-out preference signals, although it has some pretty broad exceptions. So you could probably bucket Texas either with the Virginia laws or somewhere in between Virginia and the rest of the Virginia Plus laws. I think this spectrum generally works, but it's getting increasingly harder to try and put the different states on the spectrum because some of these states have their own idiosyncratic elements.
Yeah, that's a pretty complicated landscape, and I guess like looking at it really broadly, we just talked about this particular type of law, which is this consumer privacy law inspired by the California Consumer Privacy Act, dealing primarily with data transfers, primarily built on a notice and choice model of provide a privacy policy and opt out with maybe a little bit of stronger protections here and there, and occasionally an opt in with some of the laws. There are other laws too, and we've seen the health privacy laws like the Washington health law. And if we go back a bit, we have the biometric privacy laws, but I think we're going to see more like the Illinois Act, the BIPA at some point. But to keep our focus on the laws that you've been talking about, the consumer privacy laws. Florida's interesting because that kind of breaks from the model in a bunch of ways. In some ways, if you look at the law, the contents of the law look a lot stricter, but the law seems to apply to a very narrow class of companies, like incredibly enormous ones. And I'm wondering, like what you think about the scope of that. Is that one that essentially really only a really small number have to worry about?
Yeah, I think that that's right. So just to recap, for those who haven't looked at the scoping language, the Florida law, has the typical stuff that most of these state laws have in terms of applying only to entities that conduct business in the state and determine the purposes and means of processing. But as you alluded to, it also requires that an entity has to make in excess of $1 billion in global gross revenue and satisfy one of three alternative tests. One is deriving 50% or more of the revenues from the sale of advertisements online. So really focused on companies in the ad tech space. 2, operating a smart speaker or other similar integrated virtual assistant type technology. 3, operating an app store or a digital distribution platform that offers at least 250,000 different software applications. So, I think, even having to have $1 billion in gross revenues probably carves out a fair number of companies, and then those alternative tests further narrow the scope of companies to which it will apply in a pretty significant way. It's probably a good opportunity to flag that most states have very different triggers. So most states look at the number of state residents whose personal data is processed. So in many cases, it's 50,000 state residents. Delaware, I think, is as low as 35,000. Other states have 100,000 as the trigger. I do think, though, that we're starting to get to a point where, some companies are taking more of a national approach, given that we now have more than a dozen of these laws. And so if a company thinks they meet the thresholds for California and Colorado, or California and another Virginia plus like state, they may be rolling out a program that is intended to apply nationally and honor these similar principles nationally. Not everyone, and it's not required, but when we speak later about compliance strategies, I do think that's something we'll see.
Yeah, so the Florida law, I guess I would say, I think they might have had specific companies in mind there, possibly, a few big, Disney or Meta or some others that might be in there, but it seems like just a very, very few that have this particular ad model and that particular big size. I do think it's interesting that there is this private right of action, and I also wonder, at some extent, will Florida, when the government changes at some point, and the particular companies are no longer in the in their sites, if they decide to expand this law, and if so, if they keep the law the way it is or not. I think that so we have these different requirements. We'll get to enforcement strategies soon, but before we get to that, there has been some very significant regulatory activity with Colorado and California, and the regulations that have come out have been a lot more than just, okay, let's just, implement the law exactly as written. There's been a lot of areas where the interpretations of the laws were taken, and put it mildly, perhaps some aggressive interpretations of the laws. Can you talk a little bit about some of the things that jump out at you in the regulations, and what things do they do that you think are particularly noteworthy?
Yeah, I mean, I'm glad you mentioned it. I do think that, so just as context for folks who don't know, California and Colorado are the two states that have express rulemaking authority and have promulgated rules. California's rulemaking process is happening in waves. So we have an initial wave of rules, and then today's conversation is very timely because the agency released, in anticipation of a September 8th board meeting, some preliminary language for their second wave of rulemaking. But I think you teed it up exactly right. I think in both cases, the very detailed prescriptive rules in California and Colorado, from a compliance perspective, are very meaningful, because the level of detail and prescription fundamentally changes the resources required to understand the legal obligations, and impose, in some cases, requirements that go beyond the statute. Some of the ones that jump out to me are, in California, the rules finalized in March contemplate that consent is required for certain secondary incompatible processing activities, even those that might be disclosed to the consumer, to the extent it's not consistent with the consumer's expectations. That's still a standard. And so there's room to look at just-in-time disclosures that are presented to consumers and things like that. But I think those who commented to the agency that the principle articulated and the rules was not consistent with the statute, were making really fair points. The rules prohibit the use of dark patterns for consumer interfaces in ways that are much more prescriptive than the statute, and apply not just to obtaining consent, but also the kinds of interfaces used for consumers to exercise rights. And then I think a big one is that even though the statute itself contemplates that companies have the option to honor global opt-out preference signals, if they don't want to post a link on a landing page to a do not sell or share my personal information link. So the statute contemplates that's optional. The rules, in a very seemingly inventive way, suggest that state that that's mandatory, and all companies have to provide 2 or more methods of opting out, one of which has to be honoring global opt-out preference signals. So and they could go beyond that, and they create standards for honoring them in frictionless ways. Those are the ones that really stand out to me in California, although certainly the new rules that we're seeing around cybersecurity audits and risk assessments and automated decision-making, those are areas where the agency has rulemaking authority. There's no statutory obligation. The statute punted to the agency to create. They're not self-executing requirements there. The agency has to create them. And so that will certainly be kind of material and novel as compared to complying with the statute. I've been talking for a while, so I won't spend too long on Colorado, but some of the ones that jump out to me in Colorado that kind of go well beyond the statute include the requirements for data protection assessments, which are very detailed and talk about, identifying who's reviewing and approving, name, position, signature of those individuals, more detail than, in GDPR, and certainly more than under the other state statutes and the Colorado statute. There's specifications for a universal opt-out mechanism and a whole new framework that's been created that contemplates the Colorado Department of Law will maintain this public list of universal opt-out mechanisms. There's new requirements for bona fide loyalty programs and the disclosures that are required to consumers. So a lot of areas where just looking at the statute in Colorado wouldn't be enough if you were trying to get an A+ grade in your compliance.
So yeah, a bunch of things to talk about here. One, I've always my verdict is out on the this global opt-out. I think that we've seen all sorts of attempts to try to create some kind of automated way for people to manage their privacy. P3P in the past, and then there was the do not track, and all of them have failed. And I guess I'll reserve my verdict, but I kind of think that I'm not optimistic about that as the ultimate legislative solution that's going to be the magic trick that's going to revolutionize privacy, like maybe some of the drafters of these laws hope for. But nevertheless, it's going to require companies to do a lot of work to try to, effectuate this in practice. On the DPIAs, how many, or how? I think that the California one is something where they are provided to the regulatory agency, the CPPA. Are any other states where that's the case? Because that's pretty new. Because typically, the data protection impact assessments were largely an internal thing. Companies would do them internally, and only maybe in a certain case where there'd be a regulatory investigation would they ever be shown. I think that's how the GDPR generally works, but I think some of the California and maybe other laws are making them much more routine, like something you provide. Is that right, or they're all just internal?
No, the other states. Yeah. So I'll talk about a little bit about California, because this is an area where today's release of this initial draft of rules shed some additional light on what California is contemplating. But the other states contemplate this as sort of an internal document that the AG can request. They do address, companies typically based on statutory language, don't lose privilege if they share it with a regulator, but it's not, to my knowledge, and I may have missed a state, but I'm not aware of another state offhand that requires that to be affirmatively submitted to regulators. Since it's timely, I'll just flag again, these are preliminary rules. These aren't even out for rulemaking. This is a set of draft rules that appears to have been released to facilitate board discussion and public participation at the September 8th board meeting that the agency is holding. But that draft does contemplate pretty detailed risk assessments. And then it provides that businesses will be required to annually submit their risk assessments in an abridged form to the agency, as well as with a certification by a designated executive that the business has complied with the relevant requirements. They also contemplate that kind of annual certification by businesses that they've done the cyber audit that will be contemplated by the cyber audit related rules that the agency is looking at. And I think it is really impactful. I think there are questions about the extraterritorial application of the CCPA. There's questions about the application of the CCPA to certain businesses, most of who are in regulated industries, so who are largely exempt from the CCPA, but might still meet sort of minimum revenue threshold requirements and things like that. So I think it, especially for those companies, it seems novel and undesirable to be in a position of having to make any sort of annual certification or submission to the agency, and a pretty unique requirement, novel requirement.
Yeah, I think that I've always found this interesting, and I don't even know where to come out on the issue, because part of me thinks, hey, it's great that they're, for accountability purposes, that this go to the regulator, so the regulator can really understand, were all the risks assessed and how are they addressed. There's a lot of really helpful things to get a handle on their job to regulate, and also it forces companies not just to do some empty paperwork and shove it in a drawer and not really respond to it or do anything with it or do it badly. So it forces it not to be just a checkbox. On the other hand, though, it does have a cost, which is that if this is going to be brought to the given to the agency, a company is going to try to be more careful and lawyer it up, so that, because if they truly honest and they really lay bare some of their concerns that they're not totally sure about, once it's no longer internal, that then could be a problem for a lot. It could affect Canter. And I'm wondering, is the trade-off worth it, do you think? Or I guess we're going to find out. But
yeah, I mean, I have a bias, but I sort of struggle with it too. I think you get some value, even if in terms of accountability, even without it being submitted to the agency, right? The fact that you have to do it and certify that you've done it, may be enough to make more companies who aren't doing it as a matter of privacy hygiene, to do it and take it seriously.
one other thing I'd love to tackle a little bit is one difference in the laws is that California applies to employee data, I should say. And I don't think the other laws do. I think California is an outlier in that. California is always kind of an outlier in almost everything. And what are the implications of that? How has that been affecting companies? How has that been rolled out? Because it's kind of like a tack on to some extent to add the employee data in a law that's really primarily designed around the consumer.
Yeah, I think that's right. So in the rulemaking that the agency conducted last year and earlier this year, you saw a ton of industry comments highlighting that various requirements didn't make sense in the employment context. And that, I'm sympathetic to that. There are requirements in the rules, for example, to address expressly whether you're selling or sharing data about consumers under 16 years old. Some companies add that to their employee privacy notice because of California, but it's kind of form over substance. It doesn't really make sense in an employment context, where, at least most employers, who aren't employing, in the lifeguard business or the sort of holiday season retail business. So I think there's a lot of requirements like that just don't make a ton of sense in the employment context and are really kind of form over substance. One of the board meetings where they were finalizing the rule, there was a discussion among board members where they seemed to acknowledge that. And I think they added some language so the rules finalized in March that said something pretty vague, like the agency's enforcement will take account of good faith efforts to comply. And I think the history of the board meeting suggests that was in part done because they recognize that some of the requirements, might not, good faith efforts by employers to comply should be credited to some extent, given that some of the rules didn't make a ton of sense in the employment context. There's also been some suggestion that there could be some additional waves of rulemaking that would be more focused on customizing how the rules apply in the employment context. But the statute, seems to apply, and it's also really focused on, consumer data, traditional consumer data rather than employee data. I'll also, since we haven't talked a lot about enforcement, there's a couple interesting things happening. The AG has parallel enforcement authority to the new California Privacy Protection Agency. And in mid-July, the AG released a press release that suggested he was doing enforcement sweep focused on employee data. So notwithstanding these questions and notwithstanding sort of the agency's trepidation about pursuing enforcement, at least without looking at good faith efforts to comply, the AG seems to have decided this is an enforcement priority, and so apparently has sent letters to large California employers asking about their privacy practices based on the CCPA. As a sort of an aside, the new rules in March, there's sort of a question about when they go into effect. A lower court in Sacramento held that they can't go into effect until 1 year after they were finalized, which would mean they wouldn't come into effect until March of 2024. But the AG and the California Privacy Protection Agency are appealing that. And so we'll see how long that takes to resolve.
Yeah, I guess that creates a kind of weird situation where we kind of have like we have enforcement, but just of the, kind of law before, and then we're going to have this additional enforcement later, depending on the resolution of this, or, a year from now.
Right.
And that's also something that's I think very interesting about the laws, is that so much turns on, what the regulations look like, and also what the enforcement looks like. You can have a good law on paper, and if you have bad enforcement, it's kind of meaningless. You could also have a law that gets strengthened through enforcement if you have really vigorous enforcement. So one interesting question is going to be, how are these laws enforced? What happens next? Because we have the laws on paper, but how are they going to look like when they're enforced? And it could take a while for that to ultimately shape up. I mean, it took a long time before we really get to see what GDPR enforcement looks like. Now it's 5 years after enforcement, we're really kind of seeing what the picture is. And it's going to be many, many years till we really see what the picture is. Some states might really ignore the enforcement, but others might really take it in some bold directions. I presume California probably would be doing that. Colorado probably, but states might change. On the kind of shifting a little bit to dealing with the compliance strategy, or actually before that, I should just mention about these other laws. We do also, and I think we're seeing, not just the consumer privacy laws in the state, but these other topical laws like health My prediction is probably we'll see some more children's privacy laws in states. We're seeing some social media laws. We're going to see possibly some other topics, maybe AI laws. So in addition to these consumer laws, we're going to see this other mix of laws that are going to overlap or cover areas that the other laws don't, and also some areas that might have overlap. Like I think the Washington My Health, My Data Act, which I did a webinar with Mike Hinsey not too long ago on. That's a very broad definition of health data for a large body of data that could give rise to inferences about health. So it's not just what one thinks of as directly related to health, but anything even indirectly related to health. And so it could really sweep in a lot of different companies. It has a private right of action, and so that would could overlap a lot of what the now Washington has tried to pass a consumer privacy law, tried a number of times and failed. But this health law is actually a lot stricter than what its law would have been for consumer privacy. But still, when it adds up when you're looking at complying with that law, if you're covered by it. I think companies are going to find out to their surprise that a lot of them are. Biometric laws and other laws, and then all the spectrum of state consumer privacy laws. And so, for companies, how do you advise them on what they're to do here? Do you just can you just do California and you're safe from everybody else because you're above it, or no, because there are some laws that are tougher than California? Do you try what's the strictest approach in every state, and then let's just come up with the kind of master key that would do it? How do you advise companies to deal with this landscape?
Yeah, I think it's even more complicated in some ways because in addition to all these new laws, there's some really interesting stuff happening in terms of litigation trends, and we'll see if eventually some of this litigation is sort of resolved on motions to dismiss and becomes less of an issue. But for the time being, there are lots of attempts by plaintiffs to use state wiretap laws and the Video Privacy Protection Act to allege that certain kinds of ad tech practices violate and create litigation exposure. And so I think it is a little bit of a mess. I mean, I think if you narrow it to compliance with the comprehensive state privacy laws we were focused on, and I would even include in that bucket the Washington My Health, My Data law and the similar kind of copycat legislation in Nevada. I think it's SB 370, as well as similar requirements that have been added to Connecticut's privacy law. I think it's theoretically possible to kind of create a set of high watermarks of kind of what companies have to do to comply with different things. You could imagine, a data subject request playbook where a company that just wants to kind of comply with every law, having a data subject request playbook that, most states require companies have respond within 45 days. They can add an additional 45 days to that. They have to give consumers rights to appeal, and there's typically 60 days to do that, but the new Oregon law says 45 days to appeal. So you could imagine, creating a list of just kind of high watermarks of what's required if you really wanted to check the box in every state on something like data subject requests, or something like, a privacy, what should be disclosed in a privacy policy. But I think in practice, this is happening sequentially. And so you have companies trying to figure out what their right baseline position should be, what sort of what are we going to focus on in terms of what's coming around the corner in July 2024 and October 2024. And because California came first, I think you have a lot of companies who devoted resources to complying with California and focused on what's required in California. And that's probably not a bad thing, given from resource perspective, given California's enforcement interests. But I think you'll see that companies will tack on sort of what needs to be added to comply with Colorado, Virginia, Connecticut, all of which are now in effect. And if they're still working on that, maybe they're still working on it, but they're partway there. And that hopefully on the comprehensive consumer privacy laws will cover a lot of what's required in these other states, at least for companies who are looking to take more of a national approach. And that makes sense given their geographic footprint. So I think there's enough commonality that we'll see kind of more of a national approach. And but that certainly, to your point, gets much more complicated when you start factoring in some of these additional laws like biometric privacy legislation and consumer health data laws and age appropriate design codes that add additional complexity and we're, I think, at an inflection point where companies are trying to figure out how to scale all of the compliance requirements to address all of the new requirements. So I think a good example of that is privacy impact assessments. Not only are they required under most of these comprehensive privacy laws, but companies probably who might be subject to the California age appropriate design code will have certain additional similar kinds of assessment requirements. And for companies who are thinking about AI responsibility and responsible AI issues, they probably also are thinking about assessments from that perspective. So I think you try and keep the whole set of relevant obligations that a company may need to consider in mind so that you can efficiently scale existing processes and leverage existing processes to try and address all of these things rather than creating 13 or eventually 20 or 25 different compliance programs for each state.
I think this is where too, like where the California, data risk assessment, privacy risk assessment really comes into play because organizations are probably not going to do a California version and then do a separate version for other states. They're probably going to do one time for one thing, and it'd be awfully weird. And I think probably problematic, right? If the California version has no risks, hardly anything, and it's very cursory, and then because they have to show it, and then the other states are very different, that could cause, I think, a lot of problems. So it's going to be like a kind of, I think, one size fits all for that. And so the California choice to make those disclosed could have an impact on how it's going to be done across all the laws. So I think that's particularly interesting.
Yeah, I mean, that's probably a more interesting example. As a practical matter, I think just given how prescriptive California is, I think for better or worse, and maybe for worse, like you see companies have these opt out of sale or share my personal information links or your privacy right links that echo language in the CCPA rules that really is designed to address California requirements, but they're using them to address all these other states. And it's a matter of California being more prescriptive and kind of coming first. But that's, I think anecdotally, if you did benchmarking, you'd see companies are really much more prescriptively tracking California than maybe what they would put in place looking at the whole landscape as it exists today if the enforcement likelihood was consistent across all of those jurisdictions.
Yeah. And I think that, ultimately, I don't think for a lot of companies they're going to be able to have different buttons for every state. So they're going to have to just choose one approach to do and come up with a uniform approach. Obviously, companies will vary depending on the type of data they have. So if they think, hey, we're not covered by the Washington My Health My Data Act, or we don't have biometric information, then they won't follow those laws. But generally, with the consumer privacy laws, they're broad enough that they're gonna, if they're covered by it, it's going to cover the things that they do. And it's going to require some of the basics of a privacy program. I think where you're really going to see these differences, or how do you in things that you just really can't do in different ways for different states. So you're gonna have to just choose an approach. It might not be exactly identical to the particular other states. But I think there too, how a law is enforced is likely to going to play a role too. If California will probably have pretty vigorous enforcement, so that's the standard that probably people will try to err to if they have to make a choice, rather than some other state where enforcement might be minimal. I mean, I don't think, like, in my view, I don't think Utah and Iowa's laws are all that serious. I mean, I'd be surprised if the enforcement is very serious either. I mean, to me, I look at those laws saying, well, here's something. It's so watered down that it's like it's like watered down Bud Light. I mean, it's so little and minimal that it's hard to imagine how a company couldn't comply with some of these laws, whereas others are much much more rigorous. And you're going to require, especially ones that require changes to a website. I just think you're just going to have to choose one approach, and then hope for the best, and that the enforcers are going to kind of not pick on them for that particular thing.
You have to, I don't disagree with that. I think you have to admire the Utah legislature. And I think one year they passed, or maybe over 2 years, they passed comprehensive privacy legislation, direct to consumer genetic testing privacy legislation, and social media regulation that obviously is constitutional questions, but pretty active.
I mean, I don't know. I'm not. The social media law strikes me as not really about protecting privacy. In a way, I can almost think it's like an anti-privacy law. But the other law, but I think they give it to them. They did something, but I'm not sure. As someone who looks at this kind of as a professor, wanting strong, effective privacy protection, I would think Utah is not my model for what they've done. I think some states have interesting ideas. The Tennessee law is kind of interesting. We'll see where that goes. The NIST exception, which I think is going to be interesting to see, if that has any effect. In terms of where things are going, what's on the horizon? Do you think anything else is going to happen this year or early next year? Anything of note, more of the same? Anything particularly interesting that's divergent on the horizon?
Yeah, just to briefly, before pivoting to that, just for folks who don't know, the Tennessee law has this affirmative defense for companies who have a policy that complies with the NIST privacy framework. It's a little unclear to me how it will operate in practice, but it also seems to suggest the regulators would look at your privacy program and whether it's commensurate with the size, complexity of the organization, as well as whether you adhere to cross-border transfer principles, which is kind of or rather the Asia Pacific Economic Cooperation cross-border rules, which is kind of interesting. In terms of new laws coming around the horizon, I guess if I had to guess, I wouldn't think much more would happen this year. I'm not as close to this as some folks who work at trade associations who have state level contacts, but by my count, I think there are only about 6 states that are still in session for the rest of the year that at least haven't passed privacy laws yet. Massachusetts, Michigan, New Jersey, Ohio, Pennsylvania, and Wisconsin. Massachusetts does have both a location privacy bill and a My Health, My Data style privacy bill, both of which had hearings, I believe, in June. So I think there's interest there, but I'm not sure that something would happen this year, for example, as compared to next year, since the legislative session runs through next year. So there's not necessarily a stopwatch we're pushing them to get it done by this year. I do think stuff easily could happen next year, though, to organizing my thoughts and kind of taking in advance of our conversation, I took a look back at some of the emails I had this spring on different states, and New York in May and June, I was getting a lot of questions and a lot of attention to proposed New York legislation, the New York Privacy Act. It had really, I think, 5 comprehensive privacy bills that were moving there, but one, seemed to particularly likely to move. So that seems like it got pretty far this year, and we're likely to see it again. I think there was a week in March when I saw that bills passed chamber votes in Hawaii, in addition to Iowa and the Washington My Health My Data Act. Bills also passed same week. Bills passed chambers in Hawaii and Oklahoma. So those seem like states that were pretty seriously considering privacy legislation. And then there were just a bunch of New England states that had hearings and had Connecticut-style privacy legislation, as well as other kinds of privacy-adjacent legislation like AI proposals that seemed like something could move. So New Hampshire, Maine, Vermont, Rhode Island, all of those states seemed pretty serious, and another place I would keep my eye on in 2024.
Yeah, and I wonder if any of it are really going to do anything, particularly bold. I mean, I think that, I personally kind of like to see a state that would do a private right of action, but not like Florida where it's limited to, 10 companies, but something that would be, a real robust private right of action, and also a state that would break away from the notice and choice approach. I mean, we've been one of my disappointments has been that. Notice and choice was kind of broken from the get-go. I mean, no one really believes in notice and choice, and no one really could, defend it pretty well, other than, and yet, these laws are coming out, and they're all, notice and choice essentially, with a couple flourishes, with a couple, some things from the GDPR sprinkled in, to give it a little spice, but it's essentially a kind of notice and choice plus type of approach, which has been criticized for 20 something years, and here it is again. And it'd be nice to see a state that tries to take something, be a little innovative and stop trying to do carbon copies of California or Virginia, but do something different. And I don't know if I don't see anything that different on the horizon. Maybe the Washington law is kind of interesting, but that's focused on, it's not like one of these consumer health privacy law. I mean, these consumer privacy laws. But it'd be interesting to see something a little different, rather than have more and more states essentially act, variations on the spectrum, to do something a little bit interesting, a little different. I don't know if you see anything like that's going to come along that's really going to be out of the box, or you think it's basically more stuff along these models that we've seen, just more of them.
Well, agree to disagree on the private right of action. I just think with the ambiguities in these laws and the inconsistencies across them, and the fact that the ambiguity is that's it's a really hard standard to hold companies to. Especially if there's litigation exposure. I do think, and I guess just to clarify on the notice and choice framework, normatively, I guess putting aside whether you think this is right or wrong, I think it's complicated. I guess I would consider some of the secondary processing restrictions in California's rules to go beyond notice and choice. I don't think this is consistent with the statute in California, but the rules, do seem to suggest that they create this question of needing consent, affirmative consent to engage in secondary processing, if it's not consistent with the context in which the information is collected. I don't have the language in front of me, but I read it as pretty substantive, but and going beyond what's in the statute. In terms of other states, I do think that we'll probably see a lot of states gravitate toward the Connecticut model. In New York, for several years, there were pretty different models. Some contemplated fiduciary obligations that data controllers would have to data subjects, and which is novel. We've seen some federal proposals like that too. It's not entirely clear what they meant, although there was at least one version of a New York bill that suggested that basically meant you need opt-in consent for any kind of processing, which would go well beyond GDPR, for example, and I also don't think is the right approach. But I think the version of the New York Privacy Act that had momentum had moved a little bit away from that, not completely, but a little bit away from that and more towards Connecticut style requirements, although I don't remember all the details. So that's I certainly think New York could do something different. Although some of the states that have less resources in their state legislatures, may gravitate toward an existing model just because it's been tested and people have kicked the tires. And I think state legislatures are rightfully sympathetic to policy arguments that having some consistency and harmonization is helpful, given that most companies operate not just in one state, but across all states.
Yeah, I mean, I see kind of both sides of things. I guess that's why I'm a professor, but I definitely see the difficulty of complying with all these different laws, and on the other hand, I do like the idea of trying different things, because I think that we're still in the early days of figuring out what actually works in privacy law. I actually think a lot of the existing things don't work in privacy law. Things even that in the GDPR, I don't think they work, even though I admire the effort to try. I think, unfortunately, I don't think consent works. I don't think sensitive data works. But that's for another day. But I do like the experimentation. On the other hand, it is incredibly hard for companies, especially smaller ones, or mid-sized ones that would be covered by the laws, but not necessarily have the resources to figure all this out. But that's, I guess, why they go to you and say, you have the magic answers, the magic solution, the formula to do it all easily and efficiently, I guess. And so, someone hopefully will come out with that. But in the meantime, thank you so much for all this great detail about what's going on and what's happened and these developments. And I think we're really on a fast-moving train with a lot of change, a lot of interesting things happening. And I appreciate your keeping up with it, and all the insights you have on what's happening and what will happen. I think that we can check back every few months, and it'll be a new story or new chapters in this story. But it sounds like, from what you say, certainly a slowdown this year, and a possibly we won't see many new laws by year's end, which is to some extent a little bit of a relief, because it seemed like we're on a pace for a law a month in the first part of this year. So we're at the end of August, and 8 months, and we have 7 laws. So that's quite a pace.
Just in case anyone's having a heart attack, I'll just clarify that these laws tend not to go into effect right away. So of all the laws we talked about that aren't in effect, Utah was enacted more than a year ago. It goes into effect in December, but then the next batch of laws that come into effect, and the broad comprehensive privacy laws, come into effect in July of 2024. So yeah. Most of these laws aren't in effect. I guess companies subject to the Washington My Health, My Data law might have something to worry about in March, but people have a little bit of, not a ton of breathing room, but it's not like you're behind the 8 ball yet.
But there's still many steps, right? There's the law, and then that time to freak out, and then you can take a deep breath, and then there's the regulation, and then you can take a deep breath, and then the enforcement starts. And then possibly more regulations, and then the cycle is starting up with the other states, because we still have about 37 other states to get into the action. So I think we're going to see this cycle go for a while. I don't predict a federal law anytime soon. I think last year was a law that did make it further than most laws have, but I still remain pretty pessimistic that we'll see Congress do anything. I think they struggle just to change a light bulb, and privacy, especially a comprehensive privacy law. It just involves so many really tough issues: private rights of action, preemption. What are the scope of the rights? There's so many contentious issues that it's not like one tough issue, which is hard enough, let alone 10 or more contentious issues. So that's why I'm just don't see it. So I think we're just going to see this play out over the next few years as more states do the laws. And I think if a lot of them have private rights of action, that might kind of put enough pressure on Congress to do something. Otherwise, I think probably not. But we'll see. So thank you so much for joining us, and goodbye, everyone.
Thank you.